Hello, everyone. I'm Cindy Olson with Benedictine, and welcome to Living Well with Benedictine. Thank you for joining us today. Today's session will be estate planning, protecting your assets during COVID-19 and beyond. For 35 years, Benedictine has been offering care and services founded on our core values of hospitality, stewardship, respect, and justice. As one of the largest Catholic senior care organizations in the country with elder care communities across the Midwest, Benedictine is proud to introduce our newest communities offering independent living, assisted living, and memory care apartment homes. Benedictine Living Community Northfield in Northfield, Minnesota, and Benedictine Windermere Way, part of the Benedictine Living Community Shakopee, Minnesota campus. Now, on to today's presentation. First, a little housekeeping. Everyone will be muted during the presentation to ensure all participants can hear our guest speaker. If you have any questions, please feel free to use the chat button and type your question. The chat icon is the little speech bubble on your screen. We will answer any questions about Benedictine and estate planning at the end of the presentation. With recent events, some of the concerns of the families we speak to every day have included concerns about the economy and the impact it will have on their overall wealth. We hear comments such as, "I am worried my resources won't last for the rest of my life," or "I won't have anything to leave behind to my children and grandchildren." I am sure our guest speaker, Laura Zdychnec, hears similar concerns. Laura is a practicing attorney at Law, Reher, Hanson, and Price. Her expertise is in the areas of elder law, estate and tax planning, probate and guardianship, and conservatorship. She is also a member of the National Academy of Elder Law Attorneys. Please join me in welcoming Laura today. Laura?
Thank you, Cindy. I think I'm on, hopefully, and you all can hear me. My name is Laura Zdychnec, and if you saw how it's spelled, I married a Czechoslovakian, so that's my only excuse. We're going to be talking today about estate planning and particularly how we plan right now in the midst of this unusual situation. Certainly, I think most of us have never been through something quite like this, and it's odd, it's different. It's why I'm sitting here in my office talking to you on a screen as opposed to in person. But our firm does exclusively elder law and special needs planning. So this kind of estate planning is exactly what our focus is. And one of the first things that I think is important to think about when you consider a plan is, what exactly are you protecting? And the first thing that comes to most people's minds is, like Cindy was just saying, is I'm concerned that my money is going to run out. Finances are a big concern for everybody. And the truth is, in our area of practice, for people who are looking at potential chronic illness or long-term care needs, that's a universal fear. It doesn't matter how much money people have, they're fearful about how they're going to pay for those things. But when you dig a little bit further, you also find out the other things that you're also looking to protect, and that can be protected by doing proper planning. That includes your family, of course, your loved ones, your friends. It also includes protecting the relationships that you may leave behind. The last thing that you want to do to your loved ones is to put them in a situation where they end up in conflict. So that's part of the planning also. And then finally, issues that may be important to you in terms of your faith, your values, what kind of a legacy that you want to leave. And in my faith community, These three are listed in inverse order. It should be the other way around, that faith, values, and legacy would come first, followed by family, friends, and finances would be the last. But we're all human, and in this day and age, it's a scary time. So my hope is at the end of all of this that you're going to have a better understanding of the kinds of things that you should be thinking about and perhaps some concrete steps for you to take. Another question that we hear pretty frequently is, can I plan during a pandemic? How do I do that? Interestingly, our office has been open since the very beginning. We never were part of the shutdown. We did stay at home and worked remotely, and we continue to work remotely a fair amount. But estate planning, because part of our practice includes end-of-life planning, has always been considered an essential service. So our offices have been open throughout this interesting era. We are meeting clients by phone. Many people are comfortable with telephone conferences. Some people, because they need to see a face, which I understand. We meet by Zoom. For some people, it's FaceTime, GoToMeeting, whatever works for the client. We will work with people to make sure that that is a comfortable environment and that they're able to feel confident in how they're moving forward. And then finally, we are doing in-person meetings with a lot of protections, obviously, when that's necessary. And for the most part in our practice, that becomes necessary when people need to sign final documents. We typically need 2 witnesses and a notary for any of those signings. So we have one of 2 ways that we handle those. For some people, they come in, they go directly into our conference room. Everyone is masked. Everything is cleaned down before and after the meeting. And we try to really limit the amount of time that our clients are exposed to staff and our staff are exposed to clients both. The other way we've handled some signings is what we call a drive-by. It's kind of like McDonald's. If you drive through our parking lot and we have you scheduled for a signing, we will bring things out to you. You sign them in your car, we'll witness, notarize whatever is needed and get them back to you. So certainly you can plan during a pandemic. And I would suggest throughout this conversation, if not now, when? You probably have a little more time on your hands. Most of us certainly have more time at home than we're accustomed to. So this is a good time actually to think about it. Plus the fact that this pandemic has all of us thinking in terms of our own mortality and end of life matters. So it's not going to give you the excuse to avoid it. It's time to do your planning. So I'm going to take you through sort of 4 basic steps that we consider to be essential to doing a comprehensive estate plan. Those 4 steps are: number 1, to get organized, which nobody likes to hear, but everybody needs to do. Number 2 is to make a plan for your estate at death, kind of the basic estate planning, what most of people think about when they think about an estate plan. The third one is to make a plan for incapacity, and that's critically important, and it's one that people all too often forget about, or they leave until it's too late to manage. And then finally, understanding what your long-term care payment options are, because if you have an understanding of what your options are and how you can make things come together for you or your loved one in the midst of what may be not your favorite part of your life, that is going to take a huge burden off of your shoulders. You're going to be able to sleep better, and regardless of what the outcome is, when you know what to expect and how to prepare for it, you're going to be more relaxed. Most of us would prefer to deal with concrete certainty about what our planning is going to look like, as opposed to, if you're like me, my sisters have always told me I'm an awfulizer. I will worry about the worst possible scenario. So we want to make sure that you understand what are your options for long-term care payment. Starting with getting organized. The first part of that is to locate your important documents. Many of us, those are stuffed away in a desk drawer someplace, or perhaps some of them are in the back of the hall closet. But you need to pull those documents out because those are going to be critical. This step may sound like the simplest part of the planning, but in truth, this step is critical to all three of the other steps of doing any kind of an estate plan. So pull out your documents, get them out of the safe deposit box, out of your safe, out from under the bed, wherever they are. You need to identify your wills if you have them, trusts if you have them, deeds to your property, insurance policies. Do you have a power of attorney? Do you have a healthcare directive? Your most recent financial statements. All of those things are critical before you can move forward in doing a plan. The next part is after you locate them, then you need to read them. Do those documents say what you want them to say? And if you have estate planning documents, do you understand what they mean or how they will work? It's very common you did a plan in 1979 and you haven't looked at it since. Well, guess what? It's time. You should be looking at that plan now and seeing, does this still say what I want it to say? Or do I understand how this is going to work? Because if you don't understand how it's going to work, why would you expect that your family will be able to pick it up and make it seamlessly work if you're not able or available to assist? And then finally is to make a list. And we're big list makers in our office. Lists of assets and income. So for assets, where does it come from? How frequent? How much? Will it increase? Will it end at some point in time? For assets, identifying what is it? How is it titled? Who owns it? Are there beneficiaries on it? What is its current value? Is there any encumbrance? All of those kinds of things. What do you own? How do you own it? How is it structured? All of that is information that we sort of force the issue. When a new client calls, one of the first things that we send them is called a legal planning information form. And it's going to ask you questions about all of these things. So if you haven't done it before, oftentimes that's when people will do it, is when we send them the LPI form, then they're going to have to go dig out all that paperwork so that they can complete that form so that we have the blueprint that we need to make a plan for them. Only the reason that planning is so important, or the organization is so important, is only when you understand what your income sources are, how your assets are structured, and what existing planning you have in place, can we be successful in identifying what do we need to do now in order to carry out your goals, in order to get you where you want to go. Okay, so that was step one. I didn't spend a lot of time on it because, you know, I don't like organizing any more than anybody else. But part two is to make a plan for your estate at death. And as I said, this is really what most people think about when they consider estate planning, is setting up a will or a trust or whatever that means. And the importance with your estate plan is life changes over time. Your family changes over time. Your assets change over time. So your planning may need to change as well, even if you've done a plan in the past. And it's really important for your peace of mind to make sure that what you want to happen really does happen, okay? This is a classic example. This is actually based on a true case that came into my office many years ago. But my client was Sam, and Sam had 3 children, Sue, Sarah, and Stephen. Don't ask me why he thought that was a good idea. But anyway, Sam had a pretty basic estate. He had a house that was worth about $300,000, and he had cash accounts of about $300,000. Sam had a will, and the will said that each child would get 1/3 of his estate. Now, Sam had also put his son Stephen on his bank accounts as a joint owner because Stephen was local, and that was going to make it easier for Stephen to help him pay bills and so forth as he was getting older. So in that scenario, Sam doesn't think he needs to do anything. He's got it all covered, right? Well, what Sam expects to happen is that Sue, Sarah, and Stephen should each receive 1/3 of his total estate, or $200,000 each. But what really happens is each child is going to get $100,000 from the sale of the house, because the house is going to be controlled by the will, but the cash accounts belong to Stephen, because that's how joint ownership works. It carries with it a right of survivorship. So at Sam's death, Stephen owned the $200,000 or the $300,000, excuse me, in the cash accounts, plus he gets 1/3 of the house when it's sold. And maybe in the perfect scenario, Stephen is a good guy and cares about his siblings, and he's going to do the right thing. But I will tell you that the vast majority of times this happens to someone, that's not how it plays out, unfortunately. So again, you don't want to put your family in a position where there's going to be conflict or where you're going to create conflict. So some basics of estate planning. First of all, is to understand that a will only controls a probate proceeding. I oftentimes will have people say, I have a will, so I don't have to go through probate. Well, that's not accurate at all. If the will has any effect, it will only be in a probate proceeding to control a probate asset. Probate assets are basically things that don't have a joint owner or a beneficiary of any kind. So that looking at how that asset is titled, it does not tell you where should this go when the owner dies. If the way the asset is titled tells you where it goes, beneficiary or whatever, then that's where it goes. And that title will control over everything else. Secondly, trusts can be wonderful tools. I'm sure some of you listening have what we call a revocable or a living trust, and trusts are wonderful tools. But make no mistake, they're not right for everyone. Oftentimes for people with a modest estate, a trust is really way more than what is necessary for them, and the expense and the management of a trust doesn't make sense. Also for people who have the bulk of their estate is held in qualified retirement money, you can't put that in a trust while you're living. And so whether or not a trust is right for you is going to be very fact dependent. Keep in mind when you're doing any kind of planning, estate planning, consider tax-wise ways to invest in the things that are important to you that perhaps aren't just getting everything to children and grandchildren, but also supporting a charity. And I did put a link here for the Benedictine Health System Foundation. There's a lot of good information and resources, and I would encourage you to go and check that out. Finally, make sure that your plan addresses the what ifs. One of the classic what ifs is, what if your intention is that everything goes to your 2 children, but what if one child dies before you? That's not something any of us wants to think about, but when you're doing planning, you do want to consider those what ifs so that you've covered that possibility, because then you don't have to run in and change the plan every time something happens. And one of the big considerations there is, will that child's share of your estate then pass to their children, and are any of them minors? Because that requires some careful preparation as well. Okay, moving on to step 3, which is making a plan for incapacity. And when we talk about planning for incapacity, this is a big part of our business. Estate planning obviously includes what happens at death, but this is what happens while you're still here. So if not as important, it may be more important. And planning for incapacity means deciding who's going to make decisions if you can't, and how are you going to make sure that they are legally empowered to do that? There's 2 areas of your life where that's an important consideration. One is finances. You need somebody who's got legal authority to step in if you can't do it anymore, to manage your finances, to pay bills, to sell or reposition your property. And secondly, then, with regard to your health care, you need someone who has authority because you have named them in a health care directive to say, where are you going to live? What kind of care should you be receiving? What are your feelings about life-sustaining treatment? These are very personal decisions. And so making those decisions ahead of time while you can, while you have capacity, while you can think about it calmly and clearly is the best way to go. It's not the only way to go. Goodness knows a lot of people do it at the very last minute. But ideally, you want to think about these things in advance, because again, that's going to be the best way to protect your family. So I gave you a little case study here. I won't take time to go through all the possible tools that you might use, but for purposes of financial planning, let's consider Pete with no power of attorney. So Pete and Polly were married for 50 years. Polly is now moving to memory care. And Polly has an IRA that names Pete as beneficiary, and Polly and Pete own a cabin up north as joint tenants. So Pete's plan is he's going to sell the cabin and he's going to use some of Polly's IRA to pay for her care. Now, Pete does not have a power of attorney. Can he do those things? And the answer is no. He cannot do either one of those things. He is, forgive me, I'm going back on the slide. He is a beneficiary on Polly's IRA, which means he receives it at her death. It does not give him any right to access or utilize those funds while she's living. And joint tenancy with regard to real estate in Minnesota means both owners or someone with legal authority to sign on their behalf have to sign off if you're going to sell a piece of real estate. So in this case, what can Pete do if it's too late to get a power of attorney for Polly? Well, he could seek a conservatorship through the court, which is the court process, which is always expensive. It's never a first choice. It's always the last choice. Or he could figure out other ways to pay for Polly's care without tapping into the cabin or the IRA. What could Pete and Polly have done before this happened would have been to execute simple powers of attorney when they both had capacity, and that would have dealt with it. It would have been just that simple. Another case with regard to healthcare decisions. So this is my case study with Stella. Stella is 88. She was diagnosed with terminal cancer, and she's been on hospice for several months. But Stella's no longer able to communicate or to voice her own feelings about her care. She had a fall, she ended up in the hospital, and the doctor is suggesting putting in a ventilator in order to extend Stella's life. So what happens in this scenario? Well, I'm not going to tell you whether she was ventilated or not. I'm just going to give you sort of the best case scenario and the worst case scenario, okay? Worst case scenario is Stella's family members, whoever they are, don't agree about what should happen, whether they should ventilate or not. So the doctor at the hospital starts an emergency guardianship proceeding. Just like a conservatorship, that's a court process, it's expensive, it's intrusive, and that means the decision is not going to be made by the family who knows and loves Stella, it's going to be made by the court. That is, a judge who does not know you, doesn't know your family, is going to make the decision about whether Stella is ventilated or not. The end result of that is lots of money spent and oftentimes relationships severely damaged. That's the worst case. That means Stella didn't have a plan in place. The best case scenario is Stella has a healthcare directive that indicated what she wanted in circumstances similar to these. And beyond that, because this is important, it's not just what you put on the form, Stella had talked to the person she named as her agent about what was important to her. And Stella's agent was able and willing to stand up to the doctor and say, this is what we're going to do because this is what Stella has told me. And again, I don't know if that means ventilation or not. Bottom line is, what is the best case is, what did Stella want to happen? And did we take the steps to make sure that that is what happened? Okay? All right, so that's the incapacity planning, having a plan for healthcare and for finances, making sure you've got a legal surrogate decision maker who can step in for you. The final piece of estate planning is understanding what your long-term care payment options are. And there are a number of them out there. It's making sure that you know how those are going to work for you. And for many people, it's not about identifying one versus the others. It's weaving together bits and pieces of different potential sources of payment in order to make it work for you. For some people, their own assets and income will be sufficient. So as I said at the beginning, the concern, the fear about long-term care cost is universal, because I've often had new clients come in, their legal planning form shows me that they've got $8 million and their big fear is, how are we going to pay for care? And my response is, you're going to write a check and you'll be fine, right? But that's not most of us. Most of us are not in that scenario. We still, though, need to understand how will our assets or income work. Do you need to tap into a reverse mortgage, pull equity out of your home to provide for your needs? How much of your income could you apply towards care costs so that you're not dipping into your assets too much? All of those kinds of things. For those of you who may have purchased long-term care insurance, This is one of those important documents. We go back to the beginning that you need to pull out and look through that policy and see what kind of coverage is that going to give you and under what circumstances. Make sure that you're familiar with that and that your loved ones who are going to be in a position of helping in those circumstances also understand that. Your Medicare, your supplemental health insurance, that's going to provide very little coverage for long-term care. For the most part, only for transitional or rehabilitative care after a qualifying hospital stay. That's a generality, admittedly, but usually most people with Medicare will get roughly 20 days fully paid in transitional care after a qualifying hospital stay. They can get up to an additional 80 days if a skilled service is still needed, but Medicare doesn't pay all of it after day 20. They're paying all but about $170 a day. If you have supplemental health insurance, that will kick in oftentimes and cover that daily copay. But once Medicare stops, your supplemental coverage stops as well. So Medicare was never intended to be the coverage for long-term care. If you or a loved one is a veteran, you need to explore what veterans benefits are going to be available, whether it's through the state of Minnesota, receiving care in one of Minnesota's veterans' homes, whether it's tapping into an additional pension benefit through the VA, whether it's just enrolling in the VA health system in order to access some of the community-based assistance that you can get through the VA. And then finally is Medicaid and medical assistance. And I highlighted these two, veterans benefits and medical assistance, in blue. Those are the two areas where in our office we spend a lot of our time, is working through the details with people of eligibility for either veterans benefits or medical assistance. What I will tell you about medical assistance in the interest of time is it's a very complex federal and state program, and the best thing about Medicaid law is that I have a job. So it's complicated. It's not something that you want to tinker with or dabble in. You should not rely on what your hairdresser said worked for her grandmother 20 years ago, because these laws change all the time, literally. But again, understanding how these things may work for you is going to put you at ease, because then you're not worrying, you're not thinking about the worst case scenario, or am I going to be out in the street? We'll come up with a plan. We'll figure out a way how we're going to weave these things together and make it work for you. Okay? All right. Then my final thoughts, and then I'm going to be quiet and see if we have some questions, is your options decrease with time. Try to avoid crisis planning. It happens a lot, mind you. We get a lot of crisis calls, but ideally you're going to plan better if you're calmer. So try to do it sooner than later. Medical assistance planning is complicated. Get help. That's my best advice for that. Everyone's situation is different. There is no one size fits all. So the fact that your sister-in-law tells her, we have a trust and everybody should have trust, and you don't have a trust, that doesn't mean that a trust is really what is right or appropriate for you. So we should have a conversation about all the organizing that you did, how your assets are set up, what your concerns are, what your objectives are, and we'll figure out a plan that's going to get you there. I may not always be able to get you exactly where you want it to go, but I'm going to get you as close as is possible, okay? Finally, get good information. The sad truth, and this is not intended as a criticism of the many financial caseworkers that work on medical assistance files throughout the state of Minnesota, because frankly, they're overworked and undertrained. But the truth is, if you call Hennepin County, for example, to request information about medical assistance, whether or not you get the right answer is frankly a toss-up. So it is important that you rely on good resources. Go to the Benedictine Health System Foundation website to get good information. Go to the Senior Linkage Line to get good information. Talk to your elder law attorney to get good information, your financial advisor, and so forth. And remember that planning is your best protection against all kinds of things. It's your best protection against taxes. It's your best protection against long-term care costs. It is your best protection against chaos. And goodness knows we have more chaos than we know what to do with right now. So I hope that was helpful for some of you, and I'll open it back up to Cindy to see if we have any questions.
Thank you, Laura. I do not have any questions showing on the chat screen. If you meant to ask a question, now would be your time to type that in there. But since we don't have any questions, I just wanted to thank everyone once again for attending. And Laura, thank you for the great information. It was really helpful. Our next webinar will be on the affordability of senior living, and it will be October 13th at noon. If you are interested in joining us for that, please check your email. You'll see an invitation coming. With no questions, I think that will end our webinar for today. Thank you again for joining us, and thank you, Laura, for the fabulous information. It was very informative, and I need to make some plans for myself now as well.
Thank you for having me.
Thank you, everyone.